Hi, everyone. I think we'll get started here. So as I said, my name is Nelson Godfrey. I'm a partner in Gowling WLG's Vancouver office. I work exclusively in the field of intellectual property, and I work both on the solicitor side and the litigation side, and work in all areas of intellectual property, including patent, trademark, and design law. And I'm here with Paul Armitage, who's also a partner in Gowling WLG's Vancouver office. Paul has extensive experience in the fields of technology licensing, outsourcing and procurement, life sciences collaboration, privacy law, anti-spam, and many other areas of technology and privacy law. And we're here today to give you a talk on some recent developments in intellectual property law, technology law, and privacy law, kind of spanning different jurisdictions across Canada. So the way our talk's going to be structured today is I'm going to start us off. I'm going to talk specifically about intellectual property, and my topic will be broken down as mentioned there, with kind of talking about some legislative changes over the last year at the outset, and then talking about a few areas of case law or some specific cases, and give you a high-level overview of some of the developments in the last year. Then Paul will take over. Paul will talk about some recent case law on tech contracts and big data, some recent case law on the constitutionality of CASL, Canada's anti-spam law, and then close with an update on privacy legislation. I also just wanted to mention, if you have any questions, please feel free to ask by the Q&A tab of your webinar screen. If you have any questions there, then we'll happy to address those. I'll address any particular to IP at the close of my session, and then pass it over to Paul, and then we'll wrap up at the end with any questions as well. Okay, so as I mentioned, I'm going to go in through some areas of legislative changes of the last year. Those include changes to the Trademarks Act, the Patent Act and patent rules, and then talk about some changes that may be and are likely to come in the future with the passage of the NAFTA 2.0 or the USMCA. And then I'm going to give you a little tasting menu of different cases from different areas of intellectual property through late 2019 and early 2020. And that'll be from kind of across the spectrum of IP law. And I picked some cases from copyright, from patent, and from trademarks as well. Okay, to start us off on the Trademarks Act, it's been some time now, or about a year and a half, since the big changes to the Trademarks Act that were enacted in June 2019. These were the most significant changes to Canada's Trademarks Act in many years. The changes include, as I've mentioned on the slide here, the adoption of the Madrid filing system, niche classification and class-based filing fees, the elimination of filing bases as a requirement in any application, adding bad faith as ground of opposition and invalidation, and adding a ground of objection that to pending trademark applications where an examiner considers that a mark is not inherently distinctive. So each of these significant changes and the many other changes that have been added come with some significant consequences for Canadian applicants. And we've been dealing with those changes, as I said, since the law was enacted and entered into force in June 2019. There's many other changes to come as a result of these changes. These include some significant changes to opposition and expungement proceedings, including the filing of confidential evidence, which has always been something that Canadian law has been sorely lacking in this area. In terms of the practical effect of these changes, we've unfortunately seen some real delay at CIPO as a result of implementing these new rules and a significant number of incoming applications by our accession to the Madrid Protocol. This has been exacerbated by the COVID pandemic, unfortunately, so there are some significant delays in examination currently. However, CIPO has hired a lot of new trademark examiners to help address this. We've also seen a flurry of applications by trademark squatters, and those primarily happened in the months leading up to the institution of the new rules and the institution of class-based filing fees. Basically, people were trying to get in under a single filing fee for $250 and get their applications on file for multiple classes. CIPO has again responded to that and has treated many of those filings as bad faith filings and put them into default. However, it's certainly still recommended, given the number of applications that were filed by third parties, that people assess whether their brands are available and file proactively to protect their brands, as we always recommend. In terms of recent changes to the Patent Act, I highlighted some changes in late 2018. That's a little earlier than I wanted to talk about, but these are specifically relate to some of the case law that I want to mention later. And that's the institution of Section 53.1, prosecution history estoppel. This basically means that patent office communications for the first time in Canadian law are now admissible in proceedings, where those communications are prepared in respect of prosecution of an application, or in a disclaimer or in a request for re-examination. Generally, foreign patent office communications would not be admissible, but we have a case that was specifically decided on that issue, and I'll provide some comments on that later. Another significant amendment in late 2018 was the significant broadening of the prior user defense, where basically the prior user defense, which previously was limited to specific devices and the use and practice of specific devices, has now been significantly broadened to cover the good faith preparations and broader acts than what was previously caught by the prior user defense. There have also been, in much more recently, in October 2019, there's the implementation of the patent law treaty, and there were a number of procedural changes to patent rules and patent law. I'm not going to go through those in detail, but I've listed them there. They generally relate to some tightening and shortening of windows for prosecution and taking various steps under the patent rules. And in terms of changes to come, potentially the most significant changes in recent law, maybe soon in the future, with the signing of NAFTA 2.0 and the USMCA. And I had to include a picture there of the three entirely uncontroversial politicians. And I'm sure you're not at all following what's going on south of the border today. So we have signature to the replacement of NAFTA was in force as of July 2020. And there's a lot of big changes coming for intellectual property law as a result of signing that treaty. So in particular, the obligations on Canada include obligations to modernize many aspects of Canada's IP laws. This includes copyright term extension, criminal penalties for tampering with digital rights management information, the restoration of patent term. This relates primarily to regulatory and administrative delays. People in the United States may be familiar with this in the pharmaceuticals context. That type of those types of provisions are going to be coming to Canadian law. Also includes additional powers for customs officials to seize and destroy infringing goods, which in the trademarks bar, we've been looking for that for a long time on behalf of brand owners. And then finally, new civil and criminal remedies for the misappropriation of trade secrets. We'll see what form that takes. That may take the form of regional or national legislation to implement something similar to the Defend Trade Secrets Act that's now enforced in the United States. And there'll be legislation to come to implement these changes, and it may be some time before these changes are actually in effect, but big changes are coming. Okay, so case law. So I wanted to basically take a few examples of different cases and give you kind of a high-level overview and what I called before a tasting menu of different cases from the areas of intellectual property law over the last year. So I want to start in September 2019. This is the case of CANMAR Foods and TA Foods. This was a case decided and considered the new file history estoppel provisions of the Patent Act. This case was successfully argued by our colleagues in our Calgary office, including my colleague Patrick Smith. It was brought in the context of a motion for summary dismissal that was brought by the defendant in a patent infringement case. So the patent issue there claimed a method for roasting oilseed. TA Foods, the defendant, argued that its roasting method differed from patented method because it didn't heat, the defendant didn't heat its flax seeds in a stream of air and didn't maintain the seeds in an insulated roasting chamber or tower. So the defendant argued that because these two elements were added intentionally during Canadian patent prosecution, they became essential elements of the claims. And the defendant submitted that based on affidavit evidence that it was clear from the evidence that the defendant did not do those things and that there was no genuine issue for trial and therefore it should be dismissed. So the court found that with the new institution of the new Section 53.1 and the patent prosecution history estoppel provisions, the claim construction in Canada now has three elements, or three prongs: the claims, the disclosure, and the prosecution history, most significantly. The court observed that while ordinarily only Canadian prosecution history is admissible for claim construction, under extraordinary circumstances, foreign prosecution histories may be admissible. And CANMAR, the plaintiff, had specifically referenced the corresponding U.S. application and acknowledged the amendments were to the Canadian claims were to overcome novelty and obviousness objections that had been raised in U.S. prosecution. So that specific reference was enough for the court to hold that this was an appropriate, quote, extraordinary case where the foreign prosecution history was admissible, and that therefore the court concluded that by making those amendments, they were essential, and summary dismissal was therefore granted. This case is very significant because it's the first test case where prosecution history estoppel was applied. And it's also significant because the court decided the matter on a summary basis without expert evidence. Traditionally, Canadian courts have been reluctant to undertake construction on a summary basis, particularly without expert evidence. But recently, in 2014, the Supreme Court of Canada, in Herniak and Maldine decision, stated that a culture shift is needed in favor of summary resolution. In recent months and and often in 2020, traditionally the Canadian courts and the federal court in particular was hesitant to decide construction on a summary basis, but we've increasingly seen courts taking steps to decide construction issues instead of on a summary basis, deciding them on a summary basis. So we're thinking that we may see increasing adoption of Markman-style construction hearings where construction is resolved at the outset rather than waiting for trial for construction issues to be resolved. So the decision was appealed, and in fact, the appeal hearing was held today. So I haven't spoken with my colleague yet to see how it went, but we'll certainly see, and certainly it's one to watch because it was the first test case to deal with prosecution history estoppel. Okay, changing gears a little bit. This is a case from the area of trademarks law, and in particular the area of comparative advertising, which is an interesting subject and is not litigated that often in Canadian law. So in this case, we're talking about the brands Duracell and Energizer, and the two of the leading battery brands. Energizer, the Energizer Bunny of Energizer is of course well known. It's the subject of multiple trademark registrations, including the registrations mentioned or shown there. In 2014, Duracell started using, the defendant Gillette, it should say, Gillette started using on its Duracell brand batteries claims that they were up to 15% longer lasting versus the next leading competitive brand, close quote, and quote, up to 20% longer lasting versus the Bunny brand. Energizer, the plaintiff, filed an action for depreciation of goodwill and other relief, and relied upon its registered trademarks in making that claim. So the decision that I'm talking about here was issued in February, and that was issued by the Federal Court of Appeal. And that relates to the defendant's motion to strike the plaintiff's claim. So at the first instance, the judge of the federal court refused to strike portions of the claim related to the use of the quote, the Bunny brand. And the court found there that the somewhat hurried consumer would make a mental association between the words the Bunny brand that Duracell used on its battery packages and the Energizer Bunny trademarks. But in that first instance, the court agreed to strike the portions of the claim relating to the use of the next leading competitive brand. In doing so, the court found that summary judgment should not have been granted, and that the federal court erred in depriving Energizer the opportunity to make its case. This is notwithstanding there was no reference to Energizer by name, the Energizer Bunny, or any other mark. So this decision really confirms the scope of Section 22 of the Trademarks Act. It extends beyond a company's identical registered mark, which was established law through the Supreme Court of Canada. It also shows that advertisers should really take care with comparative advertising. It's very interesting to note that the Federal Court of Appeal refused to strike this claim relating to depreciation of goodwill, even though there was no specific reference to Energizer by name or the Energizer Bunny or any other mark. And the fact that the Federal Court of Appeal refused to strike that claim leaves open the possibility that even oblique references to competitors in comparative advertising may be considered to depreciate goodwill. So the merits of this claim are certainly still to be resolved. The case is ongoing and is one to watch in 2021 as parties get closer to an actual hearing on the merits. Okay, so this relates to the law of copyright. It's kind of an interesting one here that cinephiles may be familiar with some of these films. I certainly love at least two of them. I've never actually seen the documentary, but I love two of these films. So this is the case of Wiseau Studio and Harper et al. This is an April decision from the Ontario Superior Court of Justice. So the film, The Room, by Tommy Wiseau, and that's the poster on the left, considered by many to be the worst film of all time. It's a fantastic, extremely cheesy movie for anyone who hasn't seen it. The Disaster Artist was a Hollywood film. It's basically, it's a dramatization of the making of the film, and they do some really interesting things with like side by side, shot for shot. In the film The Disaster Artist, it stars Dave Franco and James Franco, and it was released in May to November of 2017 and received a wide release in December of 2017. In 2016, before the release of that film, the defendants in this case completed the documentary Room Full of Spoons, a documentary that examined the room, its fans, and the creator of that film. In June 2017, shortly before the release of that documentary in Canada, the plaintiffs brought an ex parte motion in the Ontario Superior Court of Justice for an interlocutory injunction, and that was brought without notice to the defendants. So the plaintiffs were awarded their injunctive relief, and they were awarded an injunction prohibiting the defendants' distribution of the film. So because of that, the defendants were unable to release their documentary to coincide with the release of The Disaster Artist, which they had planned all along to basically capitalize on the added interest in the room generally and the subject matter of their documentary. So in October 2017, pre-trial, the injunction was lifted, and in lifting the injunction, the court had some very nasty things to say about the plaintiffs, including that the plaintiffs fell well short of the full and frank standard required to obtain an ex parte injunction. This Ontario Superior Court of Justice case, released in April 2020, relates to the substantive claim for copyright infringement and moral rights infringement. So after that injunction was dissolved, the plaintiffs pushed their case forward to trial, and this is the result of that trial. So in the result, this is a case that relates specifically to copyright infringement. The factual background first. Approximately 7 minutes of clips worth of the room were included in the documentary Room Full of Spoons, and the court agreed with the plaintiffs that 7 minutes reproduced was a quote, substantial part of the plaintiff's work, finding that from a qualitative and quantitative perspective, 7 minutes of clips worth of the plaintiff's work is enough to constitute a substantial part for the purposes of Canadian copyright law. But after finding that the defendants had taken a substantial part of the plaintiff's work, the court then went on to consider the fair dealing defense, which is available under copyright law to users. It's been characterized by the Supreme Court of Canada as a user's right under copyright law. And that allows parties to reproduce works for research, private study, news reporting, criticism, parody. There are specific defined categories that count as fair dealing. And then there's a separate requirement that your dealing actually has to be fair. It has to be fair what you've taken from the plaintiff and used for one of those purposes. So the justice in that case found that the use of clips from the room was for the allowable purpose of criticism or review, and referred to the documentary's discussion and analysis of the movie. The court also found that the clips were used for the allowable purpose of news reporting, given the cultural phenomenon surrounding the movie and its director. And then considering all the circumstances, the court found the dealing was fair, and the claim for copyright infringement was dismissed. This claim is significant, this case is significant because there really isn't that much law in Canada dealing with the fair dealing exception to copyright infringement. Generally speaking, it is often pleaded by defendants, but rarely is it made out. So this is a case where it was made out, and will provide some kind of guidance going forward in the future in circumstances where it may be allowable to make use of another party's copyrighted work. And then the case is also interesting for the consequences for the plaintiffs as a result of their litigation tactics. So the court awarded the defendants $550,000 USD in damages, resulting from the injunction that prevented the release of the documentary at a critical time for the defendants. And then notably, the court also awarded $200,000 in Canadian dollars in punitive damages in view of the plaintiff's bad faith negotiations with the defendants. Basically, the plaintiff had demanded exorbitant licensing fees. And the court also referred to the misleading and incomplete evidence presented on the motion to obtain an injunction, misrepresentations of third parties about the documentary, and repeated attempts to delay the trial. So in short, the court was not at all happy with the plaintiffs and how they had approached the litigation, and punished them accordingly with a very significant award of punitive damages. So this is another case, kind of changing gears again, back to the area of trademarks law. And now we're talking about a decision released in August 2020. This is the case of TFI Foods and Evergreen. This is a case that concerns the law of gray goods imports, which again is an area that's a little bit under litigated in Canadian law. So gray goods, for those who don't know, are basically goods that are imported through means that the plaintiff might not necessarily want them to be imported. They're often goods sold in other jurisdictions that may not be authorized for sale in Canada or in the jurisdiction where the complaint is raised. So it may be the plaintiff, the defendant isn't strictly speaking infringing because they are in fact reselling goods of the plaintiff. However, the plaintiff hasn't authorized their use and sale in Canada. So there's some so generally gray goods imports are not prohibited by Canadian law, but there are some circumstances where activity relating to gray goods imports may be offside of the law, and this is one of those cases. So the case relates to a trademark infringement action brought by the plaintiff. The plaintiff's the trademark owner of the trademark IMA, used in association with food products, and also another plaintiff was TFI, the exclusive Canadian distributor. It relates to products offered for sale by the defendant Evergreen in Canada, and those products feature the IMA trademarks along with a label saying that Evergreen is the, quote, exclusive distributor of Canada, and that's notwithstanding that Evergreen had never been authorized by either of the plaintiffs to distribute IMA products in Canada. So the case at issue here and the decision released in August was related to a motion for an interlocutory injunction. Oops, excuse me. Sorry about that, not sure what happened there. So as I mentioned before, that the sale of gray market goods in Canada does not in and of itself infringe a registered trademark or constitute passing off. However, in this case, the court held that Evergreen's false label stating that it was the exclusive distributor of Canada was deceptive to retailers and the public. The court found that there was harm to the reputation and goodwill in the IMA trademarks as a result of the presence of false labels on IMA products and inaccuracies in the ingredient list and nutrition facts on the Evergreen labels. So the court found that the injunctive relief was appropriate and ordered the injunction, finding that Evergreen has to cease offering for sale, selling, or labeling products bearing the IMA trademarks with labels falsely identifying them as the exclusive distributor of Canada, and immediately recall all products bearing the offending labels from the marketplace. The injunction is interesting, of course, because it doesn't strictly prohibit Evergreen from in the future selling products that are owned by the plaintiff. They simply can't sell them in the context of statements being made that they're an exclusive distributor in Canada. So the decision is an interesting one, and it recognizes that while gray good sales are not inherently objectionable, the decision does still give brand owners additional options for restraining these kinds of sales in the future. Okay, and finally, the decision of Chewy Foddy in Canada is a decision that was just released, again in August. And this may be the most significant of all the decisions that we've discussed here today. And this is a potentially landscape-altering decision relating to patent protection and the way that the Canadian Trademark or the Canadian Patent Office approaches patentable subject matter and analysis of patent applications. So that case related to an appeal of commissioner's decision rejecting a patent application. The patent application was for a method claim directed to a computer implementation of a new method for selecting and weighing investment portfolio assets. And that way, that method basically minimizes risk without impacting returns. I have a reproduction of claim 1 here, the broadest claim of the patent. I won't go through it here or read it in detail, but it is there for your edification. So the case has an interesting background in that for many years, notwithstanding the teachings of the Supreme Court of Canada, Canadian examiners have applied what they call the problem solution test, which is effectively the same thing as the contribution approach to examining patent claims in this area. So in this approach, the essential elements of a claim are those that the examiner considers necessary to achieve the disclosed, quote, solution to an identified, quote, problem. And really, a lot of those things are up for debate and discussion, and that is a significant part of patent prosecution in Canada, is identifying what are the problem and solution to be solved. And this is all notwithstanding that the Supreme Court of Canada effectively had rejected that test many years ago. So that incorrect approach was, until this decision was released, set out in the Manual of Patent Office Practice, and that manual dictates how examiners will approach the construction of these types of patent claims. So in this decision, which was released in August, Justice Zinn found that the problem-solution approach to claims construction is akin to using the substance of the invention approach, which was discredited by the Supreme Court of Canada and Free World Trust. And the court found that the commissioner had erred in determining the essential elements of the claimed invention by using that approach, instead of using the approach dictated by the Supreme Court of Canada. So I think it's just repeated that top bullet there. And really, it is really clear reading the decision that Justice Zinn recognized the import and what this would mean for patent office practice in Canada. And I've quoted there at the second bullet, quote, "It is evident on a reading of MOPOP that the commissioner, notwithstanding stating that the patent claims are to be construed in a purposive manner, does not intend or direct patent examiners to follow the teachings of the Supreme Court of Canada in Free World Trust and Whirlpool." So a very significant decision, certainly, and effectively the court has indicated that patent examiners and MOPOP is not being applied in the way dictated by the Supreme Court of Canada. And Justice Zinn used that decision, used that finding to basically find that the patent should be granted, sent it back to the patent office. Excuse me, didn't find it should be granted. Sent it back to the patent office for redetermination, is my recollection. So similar to what occurred following the decision in Amazon, CIPO and the Patent Office have now put all related cases in these areas on hold while they figure out how to deal with the decision. And the decision was not appealed. So there really are significant implications for many pending cases that are in the pipeline now and future cases. And in fact, just today, the Canadian Intellectual Property Office put out revised practice notices on how patent examiners are to handle these types of cases in the future. So I'm going to pass it over to Paul now to continue with the talk and on the next section.
Hi, thanks, Nelson. So we're going to start off the second part of the webinar by looking at a very interesting English case called 77M Limited versus Ordnance Survey. So this is a big data case. It is also a case that involves what is an increasingly common business model. And namely, that's companies that find online data sets or online services, they extract the data from them, and then they manipulate and combine that data to create their own new service. Okay, so what 77M did in this case is that they created a product called Matrix. Matrix is essentially a geospatial map of all the addresses in Great Britain. And Matrix was created by combining and accessing at least 18 different data sets. Some of these data sets were publicly available under online terms. Some of them were available under negotiated licenses. Some of them were available for free, and some of them they had to pay to access. And however, Matrix included some data that derived from Ordnance Survey data, Ordnance Survey being the National Mapping Agency for Great Britain. So one of the first questions that the court looked at was this whole concept of internal business use. So this is a concept that is used in a wide variety of different types of technology contracts. And it's essentially a type of term of art that's used to denote that the licensee can use the product or the service for their internal use, but they can't use it outside of their organization. So one of the data sets that Matrix had access to was called the Inspire Geospatial data set. And it came with a set of online terms. And what the online terms said was that you need to contact Ordnance Survey to get a license if you need to do either of two things. One is use the polygons. A polygon is like a map representation of an address or a location for a purpose other than commercial use within your organization. So in other words, if you want to use the polygon for commercial use outside of your organization, you have to get a license from Ordnance Survey. This is similar to an internal business use clause. And then secondly, or if you wanted to actually distribute the polygons outside of your organization, you needed a license from Ordnance Survey. So of course, what 77M did was that they used the Inspire polygons to create matrix. But they did not actually distribute the polygons outside of their organization to their own users. And of course, since we're reading a case about it, they didn't go to Ordnance Survey to get a license to use the polygons. So here, we'd like to pause and do a poll question for the members of the webinar. And the question is, did 77M breach those online terms by using the polygons to create their own commercial service? Okay, I see the numbers jumping around here. So it looks like we have about 72% people saying yes, they did breach the download terms, and 28% saying no. Okay, so now turning to what the court found. So the court found that that particular clause did not prevent the use of the polygons to develop a service for sale to customers, as long as the polygons themselves were not supplied to the customer. In other words, in essence, what the court found was the words commercial use within your organization included developing a competing service. So there are a few takeaways to derive from this case. First of all, when you look at clauses that impose internal business use type restrictions, the clause has to be interpreted in the context of the overall contract in order to determine what the meaning of those words actually are. And building on that, simply using the words internal business use, that may not be enough if the licensed service could be used to create another service derived from the actual licensed service. So one thing to think about if you want to prevent that type of use of your product or service is to include more prescriptive terms in your agreement. For example, specifically saying that the licensee cannot use the licensed service to create a competitive product or service. So another thing that 77M did was that they scraped about 3.5 million records from an online service called Find a Property. And this Find a Property service had online terms, and the online terms actually prevented scraping or using automated tools to extract data. However, the way the website worked was you only had to accept the terms if you were going to make a purchase of data. Sorry, I need to go back. And so what 77M was able to do was they were actually able to access their data, or the data that they needed, without actually purchasing the data. So in other words, they didn't actually accept the terms that prohibited scraping. And so the question was, however, those terms were still nonetheless posted on the website, even if a person wasn't required to specifically accept them unless they were making a purchase. So the court found that 77M had in fact breached the prohibition on scraping, even though they had not proactively accepted the terms. And the reason for that was the court found that a reasonable user would conclude that the license terms applied to the entire service even prior to accepting the license. So here, a couple of key takeaways are, if people are accessing publicly available data sets, always check the terms that apply, even if you're not required to proactively accept them. And secondly, liability can arise even if the terms are not accepted, if the court finds that a reasonable user would have considered them binding or would have understood them to be the terms that apply to the use of the service. Okay, so the final aspect of 77M we're going to look at is was actually a negotiated license. So in addition to accessing these publicly available data sets, 77M actually negotiated a license with the Registrar of Scotland to use two types of data, house price data and house type information. And under the terms of the negotiated license, all other uses or other parts of the data that can be accessed can only be used for internal modeling purposes. And so what 77M actually did was, they weren't actually interested in the house price and the house type information. What they really wanted access to was all the geolocation data that was sort of embedded in the data they were accessing. And so what they did was they took the geolocation data and they used that in order to create matrix. This the court found to be a breach of the negotiated license because they were using the geolocation data for purposes other than internal modeling. So here, the key takeaway is that, you know, when a person is negotiating a license, make sure it gives the organization all the rights that it needs. Okay, so we're going to switch now and look at the CompuFinder case, which deals with the constitutionality of Canada's anti-spam law, or CASL. So a quick recap of the facts. So CompuFinder is a professional training course company, and its primary means of business development was through email marketing. The CRTC investigator investigated CompuFinder in 2014, and they found that CompuFinder had committed various breaches of CASL, specifically sending out email marketing messages without consent. And some of those messages had two unsubscribe links, one that worked and one that didn't. And the court found that the presence of this non-working link was enough to cause a breach of CASL's unsubscribe requirements. The CRTC investigator issued a notice of violation for $1 million. CompuFinder took that to a hearing before the CRTC, which reduced it to $200,000, and then CompuFinder appealed to the federal court. So the federal court first looked at the whole question of constitutionality of CASL. And the first thing they looked at is whether or not CASL is covered by the federal trade and commerce power, as opposed to being a matter of property and civil rights, which is a matter of provincial jurisdiction. And here the court actually broke CASL into three different pieces. They had the piece dealing with marketing emails, piece dealing with installation of computer programs, and the piece dealing with address data and things of that sort. And so looking at the CEM regulatory scheme, they said that the pith and substance of that regime is to protect Canada's e-economy against the threat of spam. Spam was considered to pose a significant threat to privacy and security, and that the CEM regulation scheme was directly tied to achieving the purpose of controlling spam. And because CASL applies to the nation as a whole and not to a specific industry, it was found to have a national purpose and therefore fall within the trade and commerce power. The next question was whether or not CASL involved an infringement of the Charter guarantee against restrictions on freedom of expression. So here, everyone actually accepted that CASL did restrict freedom of expression in the form of business communications. However, the court held that this was a justified limitation. And here the court noted that inside CASL, the definition of a commercial electronic message, or CEM, is not vague so as to be unconstitutional. So I'll pause here to make a general observation. So from the days that CASL was first introduced, there's been sort of two differing views about CASL. On the one hand, there being commentators or people who say CASL, it's too vague, it's too detailed, it's too difficult to apply in real life. No one really understands what it means. We should just throw the whole thing out the window and start again. On the other hand, those types of arguments have been met by people, particularly on the regulatory side, with a certain degree of exasperation. And they've basically said, what is so difficult? All you have to do is read the act, read the guidelines we put out, follow the rules, and you can comply with CASL. So these two different views of CASL were on heavy display in this court judgment, with CompuFinder arguing things like vagueness, to try to strike down Castle as unconstitutional. The court, however, heavily came down on the side of what's the big deal? All you have to do is understand the rules and comply with them. At one point, the court even referred to CompuFinder's submissions in this regard as hyperbole. From the perspective of the court, Castle, in order to comply with Castle, all you need to do is have consent, include an unsubscribe mechanism, and include the necessary contact information with your message. So the court found that this regulation of CEMs was rationally tailored to its objective. And it also found that it was a reasonable way to solve the problem or approach the problem. And here the court contrasted Castle with a couple other legal regimes out there that regulate spam. So they looked at US CAN-SPAM. So US CAN-SPAM is purely an opt-out approach. The court considered that to be insufficient as a way to combat spam because it doesn't prevent spam from actually reaching the inbox of the recipient. They also looked at the Australian approach. So in Australia, their anti-spam regulation, it has a closed definition of what a CEM is, but then an open-ended concept of inferred consent. Whereas Castle works the opposite way. It has an open-ended definition of what a CEM is, and then a series of closed categories of either exemptions or implied consents. But the court looked at this and said it's really just 6 of one, 1/2 dozen of the other. One can't be said to, restrict free speech more than the other. And then finally, and perhaps most importantly, the court commented that Castle deals with commercial expression, and commercial expression is not as strongly protected under the Constitution as other forms of expression. So the court also said that Castle is not a criminal enforcement regime and therefore does not violate the presumption of innocence or security of the person. And they also found that the investigative powers under Castle do not constitute unreasonable search and seizure. So setting aside the constitutional arguments, the court also touched on a few of the actual substantive provisions of Castle, and they looked first at the business-to-business exemption. So the B2B exemption, as many people will be aware, it completely exempts from Castle CEMs that are sent between two organizations that have a relationship, as long as the CEMs are relevant to the activities of the recipient. So here what CompuFinder had argued was, well, we had provided training in the past to specific individuals at these companies. That was enough to create a relationship between us two companies to allow us to send these messages. The court agreed with the CRTC that that was not sufficient to create a relationship under the B2B exemption. Essentially what they said was, under the B2B exemption, that it allows organization A to send messages to anyone within organization B, and therefore, in order to establish that type of relationship, it requires a much higher evidentiary hurdle. On the other side, however, they found that when analyzing what the activities of the recipient are relevant to the analysis, they said that one can't just look at the core business activities of the recipient. One can consider other types of relevant activities of the recipient when judging whether or not the message is relevant to the recipient. So the court then next turned to the implied consent for conspicuous publication. So here, under Castle, there's an implied consent to send a CEM when a person has conspicuously published their email address and the message is relevant to the person's business, role, functions, or duties. So what CompuFinder had done here is they'd gone to a bunch of websites, they'd gone to the contact page, they'd code out some email addresses, and they'd said, we're only sending messages to people, relevant people within the organization based on what we found on their website. The court found that that's not sufficient. The court said that you can't simply, for example, by looking at a job title of a person that may be posted on a website, that easily come to the conclusion that the message is actually relevant to their role within the organization. Rather, this relevance must be assessed on a case-by-case basis. And this finding is consistent with previous decisions of the CRTC on the same point. Finally, the court looked at the unsubscribe mechanism. As I mentioned earlier, there were actually 2 unsubscribed links in the messages. One of the unsubscribed links worked, the other didn't work. The court upheld that this was a breach of CASL on the basis that it is confusing and frustrating to someone looking to unsubscribe. So we're going to shift now to our privacy law review. The first thing we're going to look at are the amendments to the BC Freedom of Information and Protection of Privacy Act, dealing with in-Canada storage and access. So just to level set, under FIPA, a BC public body must ensure that personal information in its custody or control is stored and accessed only in Canada unless one of three things: the individual consents to outside Canada storage and access. The outside Canada storage and access is allowed under a FIPA exception, and there are a variety of specific and time-limited exceptions to this basic requirement in FIPA, or if a ministerial order is made allowing the outside Canada access or storage. And so the Minister of Citizen Services has the power to issue these orders. Over the course of FIPA, perhaps a dozen or so of these orders have been issued, but generally speaking, they're directed at very specific things. They don't, for example, exempt entire use of a service or a particular product or anything of that sort. But we're going to come back to the ministerial order in a moment. So what the amendments did is they added two new exceptions to the in-Canada storage and access requirements. First of all, automated processing of personal information outside of Canada, but without storage outside of Canada, is permitted as long as the data is only accessed by a machine and the access outside of Canada is temporary. The second exception is that electronically generated metadata about the use of an electronic system can be disclosed outside of Canada as long as the personally identifiable information is removed if practicable. So there's some, permissive aspect to that. And this metadata is not used for any other purpose. For example, no sort of secondary purpose. Okay, so what is going on here? So effectively, these are very targeted changes to FIPA to deal with specific aspects of some commonly used business tools that involve online or cloud type services. And they're really meant to be create some narrow exceptions to deal with some specific circumstances, the way certain services tend to operate, such as aspects of email services, spam filters, web analytics services, word processing programs that keep track of metadata. Perhaps that metadata is stored and processed outside of Canada as part of the functioning of that online service. So in other words, these are very limited, specific new exceptions. They don't permit sort of the general use of a cloud service, but they are reflective of what's been an incremental approach under FIPA to expanding outside Canada storage and access. So rather than grant broad exemptions, we've had, with these most recent amendments, plus with amendments in the past, much more specific and targeted incremental type changes. Now, perhaps reflective of the strictness of the requirements of in-Canada storage and access, the Minister of Citizen Services did issue a ministerial order earlier this year, and it's time limited to stay in effect to the end of the year, effectively to loosen up outside Canada storage and access of personal information in the context of dealing with the COVID-19 disease, subject to certain conditions. Okay, so we're going to move now to a brand new area of privacy law enforcement, which is the signaling by the Competition Bureau of Canada that they will begin to police breaches of privacy law as breaches of the Competition Act. So essentially what the Competition Bureau is doing here is that they're bringing truth in advertising regulation to privacy law practices. So in other words, if companies make false or misleading claims, such as in a privacy policy, about the type of data they collect, why they collect the data, and how the company will use the data, that could be found to be a breach of the advertising rules enforced by the Competition Bureau. And of course, the significance to this is that the Competition Bureau has very strong enforcement powers. They can levy administrative penalties against companies of up to $10 million for a first offense and up to $50 million for subsequent offenses. So this can be contrasted with our privacy commissioners. So our privacy commissioners are really built on an ombudsman type model. So the privacy commissioner can investigate, they can report, and if they find a violation, they can try to resolve it amicably. And if they can't resolve it, they can publish a report and name and shame the company that committed the breach. However, they have no real enforcement power, and specifically, they have no power to administer fines or penalties themselves. So with the Competition Bureau entering this area, this opens up a much, in terms of organizations' privacy practices and what they disclose in their privacy policies, this opens up a new dimension to the potential consequences of that. So now we're going to finish off the webinar with just touching on some of the privacy law reform initiatives underway in Canada. So at the federal level, PPADA, in the most recent annual report, the Federal Privacy Commissioner indicated that PPADA is considered to be outdated. It does not sufficiently deal with the digital environment and specifically deal with adequate regulation of new technologies. Secondly, on top of that, the Privacy Commissioner has asked for much greater remedial powers. This picking up on the comments a few minutes ago about the ombudsman type role of the Privacy Commissioner. They'd like to shift away from that model to really more of a European style data protection authority type model where the Privacy Commissioner will actually adjudicate disputes and have the power to award monetary penalties. Now, it seems likely that there will be a major overhaul of PPADA in the near future. However, we don't yet know when this might occur. The government actually first signaled that they were looking at PPADA for these types of issues over a year ago when they announced the digital charter. So in the interim, Quebec has moved forward with its own bill. This bill addresses the modernizing of Quebec's both public sector and private sector privacy laws. And essentially it's for the same reasons. There's a feeling that the data protection laws are out of date and a complete overhaul is proposed. So some of the things that are included in the Quebec bill, much more robust consent requirements. They've also included a number of sort of GDPR type rights of the individual, such as the right to be forgotten, the right to be informed of automated decision-making, privacy by design concepts. There's also a new regime dealing with outside of Quebec communication of personal information. Mandatory breach reporting, which is not currently a feature of the Quebec Act. And finally, once again, beefing up on the enforcement side. So the Quebec Privacy Commissioner will now have the ability to, if the bill gets passed, have the power to issue administrative monetary penalties of up to $10 million or 2% of worldwide turnover, or for offenses under the Act, those could be punishable up to 4% of worldwide turnover, which of course is very reminiscent of the enforcement powers of the DPAs under the GDPR. And on top of that, there would be a private right of action and minimum damages for intentional or gross fault. So Ontario, in August of this year, they similarly signaled that they are looking at overhauling Ontario private sector privacy laws. So as most people will be aware, Ontario does not currently have its own broad-based private sector privacy law. Instead, it relies on PPADA. So the Ontario government released the consultation paper titled Improving Private Sector Privacy for Ontarians in a Digital Age. So you can see the theme here once again. The laws need to be updated to deal with new technologies and the digital environment. And the consultation paper touched on a number of things that they may be looking at doing. Once again, a new consent model, much more closer to the consent model under the GDPR, which includes concepts such as legitimate purposes, and then reserving opt-in consent for more specific things such as secondary purposes. A number of GDPR type rights, right to be forgotten, data portability. Yet another aspect to the consultation would be to fill in gaps under PPADA. So currently PPADA does not apply to, for example, the nonprofit or charitable sector, and it doesn't apply to employee personal information outside of federal works and undertakings. And once again, the Privacy Commissioner would be looking to add the ability to levy fines. So finally, in British Columbia, we have our own review of the Personal Information Protection Act being done by a legislative committee. This is the required review that is supposed to occur every 6 years. A variety of organizations have made submissions that can be found on the BC government website. And there will be a report slated for release in February of next year about whether or not any amendments to PIPA will be recommended. And that's the end of the official part of the presentation. So I'd like to thank everyone for joining us today. We do have a few minutes left here for question and answer. So I'll just quickly see what questions we have. Okay, so the first question is for Nelson. Other than software patents and medical diagnostic methods, is the problem solution approach used in other arts?
So my recollection is that, and I have not yet reviewed the revised guidance from CIPO, but my recollection is that this will have significant impacts not only with respect to software patents and diagnostic methods, which is recognized there, but medical uses as well. I think will be another area where this could be highly relevant. So those are some of the primary areas where this approach was used. If the broader question is it used in respect of simple machines and those basic types of patents, there is kind of an implicit recognition amongst examiners when you're discussing with examiners. That's kind of what they're looking for. But it isn't enforced as strictly, and it wasn't specifically referred to in many other areas of MOPA and patent examiner practice.
Great. So the next question is, what is the rationale for the significant reduction in the monetary penalty in the CompuFinder case? So if you recall, the original CRTC investigation levied a fine of $1.1 million, and the CRTC on hearing reduced it to $200,000. So the main reason for that was, so under CASL, there are a series of criteria that go into assessing what the right penalty was. And the CRTC hearing felt that the $1.1 million fine or penalty, it had been assessed more on the theory of general deterrence to the industry or any company out there. Whereas the CRTC said the correct analysis, well, what is the right penalty to deter this particular company? And so they felt that the $1.1 million focused on general deterrence, and the $200,000 was sufficient to deter that specific company. So the next question is, do you think BC would delay introducing changes into the federal updates to PIPEDA? I think that's quite likely. So obviously, PIPA has to maintain its substantially similar status to PIPEDA. And so they can't really do that until they know what the new PIPEDA looks like. Interestingly, it's a bit of a domino effect, because PIPEDA has to maintain its adequacy to the GDPR in order to maintain the information flow from Europe into Canada. So in other words, PIPEDA has to maintain its adequacy status. And so they're looking at what the amendments to PIPEDA needed to do that. And then once those are in place, then PIPA has to look at what's needed to maintain substantially similar status to PIPEDA. So I'm not aware of any official word on that, but I think that is quite likely how things will play out. Okay, next question. If my company follows the GDPR rules of engagement for privacy of data, are we okay in Canada? Yeah, that's obviously quite a complicated question. So obviously GDPR is sort of the high watermark of current privacy law regulations. And so if you're doing everything you're supposed to under GDPR, you're probably doing, in some respects, you're going above and beyond what may be required under Canadian privacy laws. However, the regimes are different. For example, in Canada, it's essentially a consent-based regime, whereas in the GDPR, they have this concept, for example, of legitimate purposes, where you don't necessarily need consent of the individuals to do certain things. And so there's those types of differences and those types of variations. So it's not something, you can't automatically assume that because you comply with GDPR, you will comply with Canadian privacy laws. Although if you are complying with GDPR, in all likelihood, you have robust policies in place that are, I mean, in some respects, going beyond what's required under Canadian law, but in some respects, they may not be the perfect fit. Okay, I think we'll just finish off on this one last question. With the previous exemption that covers a public body that sends an email to a service provider, and that email contains sensitive information that the email is routed to US servers. Yeah, sorry, I think the question is, so currently, about a number of years ago, there were some previous amendments made to FIPA, essentially to allow the use of certain types of email services that were cloud-based. But here, the context of that amendment was really people using email services that were not strictly solely based in Canada to email public bodies. And then when the public body wanted to turn around and respond to that individual using the same means of email communication, there's no guarantee that so the public body was under an obligation to make sure the data stayed in Canada, but by replying to an individual using one of the email services that the individual had used, the data could transit outside of Canada. And so there was a specific amendment made to FIPA a number of years ago in order to permit those types of responses. However, they did not actually permit the public body itself to use, for example, a cloud-based email service that would include storage or access of data outside of Canada. So that previous amendment that still exists and it still applies. The new amendment is really not so much about the email service itself. It's really about if there's aspects of it, for example, metadata or temporary processing and things of this sort. It won't actually permit, the routing of personal information through an email service, through a foreign country. Okay, so I think we're at time. So I think on behalf of Nelson and myself, I'd like to thank everyone for joining us today, and we wish you a pleasant rest of your day. And we look forward to any further questions people may have, and hopefully hearing from a number of you in the future. Bye for now.